All right, we'll get started. Welcome, everyone. My name is Brian Denger. I work with Ryan Fisher in community engagement for Parent Project Muscular Dystrophy. And it's my pleasure to welcome Leona Filis with the Filis Law Firm. Her session is titled Financial and Estate Planning for Your Family. And actually, it's significantly more than that. It's a very robust session about the various benefits and financial planning that you would undertake as a family to protect benefits and to protect families who are affected by a significantly seriously chronic condition where you are relying on state medical benefits. Leona is with the Filis Law Firm. They were established 18 years ago, and they now focus on special needs law. The information, as I said, is very information rich. So Leona has graciously put together a PDF of her slides. So should folks wish to avoid taking notes, they just want to pay attention, you can email me after the session, and I'm happy to email the slides to you in the next day or two. My email for Parent Project Muscular Dystrophy is my first name, Brian, B-R-I-A-N, at parentprojectmd.org. And as I said, I will send it the next day or two. The other offering that Leona has is she has a Facebook group. It's Duchenne Legal Information for DMD Families. And while Leona is not licensed to practice law in every state, she can provide some guidance without providing actual legal assistance and guide people towards being better self-advocates for themselves and for their families. So without further ado, I will turn it over to Leona and we will begin this session. Thank you.
Thank you, Brian. Thank you so much. I really appreciate being invited to attend this conference and to speak to parents. Today, we wanted to talk about financial planning and estate planning for families with children with special needs. And as Brian said, I'm located in Houston, Texas. But what our information pertains to is benefits that are provided through the state and federal government. So hopefully we can at least, if we're not addressing your state's benefits, we can at least touch on things for you to investigate on your own within your state. We're also going to have the chat and the question and answer open. This is more of a conversational presentation, so feel free to put some questions in chat and we'll try to address it when we get to that topic or address it at the end. So let's go ahead and start. For me, I had a diagnosis for my son of autism spectrum disorder. At the time that he was diagnosed, it was PDD and OS. Later, we added the ADHD condition to my son's diagnosis. And I had seen from dealing with other families with children with special needs that a lot of legal issues were not being addressed. So I started investigating and seeing what I can share with other families to make their lives easier. So one of the first things that I ask parents to do is to look at their state's Medicaid waiver programs and sign up immediately. And we'll discuss in a little bit why it's so important to go ahead and make that call today, even if you can. That is something that parents can do on their own. And then also later on, when your child reaches the age of 18, you can look into SSI and Medicaid. You'll probably want to have something called a special needs trust or supplemental needs trust. I encourage parents, both parents, caregiver and breadwinner parents, to get life insurance and disability insurance. Updating your wills, investing in a special savings account called a 529A account. And then we'll also talk a little bit about guardianship or lesser restrictive alternatives. So the main topic today is going to be about benefits for your children. They're Medicaid waiver programs. So waiver programs are administered at the state level, but it's a federal and state run program. And it's for children and adults with disabilities. Now, these services are provided to the individual for free. So that's wonderful. The problem is that a lot of people find, especially those in Texas, that it could be years before your child comes off of the interest list, which is a waiting list, to be interviewed to see if they're eligible for these benefits and then to start actually receiving the benefits. So for example, in Texas, we have about half a dozen programs. One of the programs which benefits a lot of families with children with Duchenne is the MDCP, Medically Dependent Children's Program. So that particular program will offer free services and support to the family. Some of this support can include respite care, personal care attendant hours, where you will have a budget in order to pay someone to come to your house and help you with your children. You also have some programs which allow for therapy and will pay for therapies for your children. This is a chart that we have found from November 2019. So this again is for Texas specifically, but it's handled through Health and Human Services. So every state has their own branch of the Health and Human Services Commission. And what you'll see here in the blue are the different waiver programs, Medicaid waiver programs that the state offers. The main number I wanted to...
If I could just interject one thing, Leona. So as Leona has mentioned, there are 50 different states and the programs vary from state to state. What you may find is some of them go by these different terms. Katie Beckett waiver might be something that people will, or medically fragile children's programs. So each of these states every state has something, but the criteria and eligibility will be different from state to state. And unfortunately, just the diagnosis of Duchenne is not an eligibility, or it's not the gateway. It's going to be needs-based. So great advice from Leona. Speak with folks, try to find a case manager who is helpful at your Department of Health and Family Services or Health and Human Services to get some of that information right off the bat.
Now, to your point, in Texas, it does vary from state to state, these programs do, and the criteria for a lot of the Texas programs is different, where it's not needs-based for the family. So to be eligible for services from some of these waiver programs, the part that's waived is the requirement that your household income and assets be at a very low level. Now, the Social Security will look at your child's or the individual's income and assets, but not household. So, for example, for me, when I first heard about these Medicaid waiver programs, I didn't sign up. I did not sign up because I thought I'm never going to qualify for something that's related to Medicaid, where in fact, I found out later and then did sign my son up. The requirement where household income must be at a certain level near poverty was waived. From this particular chart, if you combine all the people that are on these waiting lists for these Medicaid waiver programs, it's close to 285,000 people that are waiting for free services and support. That was a couple of years ago. Now, the most recent chart that's been provided by Health and Human Services for Texas Medicaid waiver programs shows that this total number increased to 305,000. So it's very important, as soon as you have a diagnosis, to contact your state and local authorities to see what benefits your child may be eligible for and get on the waiting list. To bring it home, in Texas, the wait for years, the amount of years that you're going to be waiting for benefits for some of these programs can be 13 to 14 years here. For HCS, which is for home and community-based services, we're up to 16 and 17 years wait. MDCP is what I mentioned before for medically dependent children's program. That is a shorter wait list. And actually my son with autism was on that list and he came up off the list. So I was contacted by Health and Human Services and informed that we would have an interview to see if my son qualified. So I knew he didn't qualify for this. He's not medically dependent. So I asked at the time to take him off the list and put him at the bottom of the waiting list, just in case he may meet the eligibility requirements later on in the next few years. So medically dependent children's program, again, because it is for children, it's for individuals 21 and under. You must be eligible to meet SSI or institutional requirements for income, but the individual does. So most of them will be fine and won't have to worry about that aspect of eligibility. They do not, for this particular program in Texas, consider the parent's income. But there is a medical necessity that's required, which for my son, he did not meet that requirement, and I went ahead and put him at the end of the waiting list. But for those of you who have a child with Duchenne in Texas and have signed up for MDCP, one of the 6 Medicaid waiver programs, if you are qualified, if your child is qualified to receive these services, this slide shows you some of the things that you would be eligible to receive, which does include minor home modifications if you need to have ramps installed at the house, transition assistance services, getting your child back and forth to therapies and medical appointments, respite care. Now, Brian, didn't we talk about adaptive aids? What were the adaptive aids that you were thinking about?
So the biggest durable medical equipment purchase that a family will make will be a powered wheelchair, and private insurance will oftentimes approve it, but their reimbursement is very, very spartan. So the state Medicaid programs typically will purchase a more robust, more appropriate chair. So that's something that we're looking for coverage for in these programs. So
one of the other, I'm sorry.
I was going to say that there have a couple of questions that have come in, Leona, that I wanted to mention. One was in regards to a certain state's criteria, and it's the question has to do with the fact that it's the program looks for intellectual disability as one of the benchmarks, and whether there's some advice. And I think that it would be difficult for us to flesh out those. How the process for someone to go beyond that. I think that you have to look at what the offerings are in a state, and that eligibility, as well as what are offered, what services are offered, is going to be dramatically different. You and I had spoken about how in the Northeast it's typically much more generous. You go to the South and sometimes into the West, you'll find these programs are less so.
Right. So with some of these programs, there is a requirement that the IQ level of the individual be at a certain level, 70 or 75. And one of the requirements when it's a program where intellectual level is one of the factors for eligibility, you can't just use an IQ test that was performed at school or with your pediatrician or neurologist. You would actually have to go to your local authority in your county or parish and have them perform it's called a DID, Determination of Intellectual Disability. So you would, at your meeting, your interview with Health and Human Services, you would already have that determination of intellectual disability in your hand and ready to provide to Health and Human Services to show that your child meets the eligibility. There's a lot of comorbidity with DMD, where we might have an intellectual disability or autism. And so there are a lot of functionality in these waiver programs, which can address many of the challenges that your child may face. So hopefully that answers that question. And it does, again, varies from state to state. I would do a search for Health and Human Services online and type in your state, so you would get the state specific requirements.
The other question has to do with the portability of these waivers from state to state if a family relocates. And unfortunately, because it's a partnership between that state and the federal government, moving even to an adjoining state you're going to have to reapply based on what the offerings are in that particular state.
And also county-wide. So like I said, there's about 6 here in Texas, there's 6 Medicaid waiver programs. About half of them are administered at the state level and the other half are administered at the local level. So there's not the portability from county to county. I would check to verify if you're going to lose your spot in line in the waiting list.
And the last question had to do with age. Was there an age requirement for eligibility? And that will often depend on each state's program, but more typically it's a needs-based meeting nursing facility level of care or some other level of care over the fact that it's a particular age.
Right, and with let's say for MDCP, it is for individuals that are age 21 and younger. Right. But once the participant who's receiving services reaches the age of majority and ages out, they're automatically transferred to a different program. So they don't have to get back on another waiting list. One of the things that I wanted to stress is that even though there's 6 different programs, at least in Texas, you can only receive benefits from that one program at a time. So, for example, my son, like I said, came off of the interest list for MDCP. We declined services at that time. But if we had taken them, we're still on the waiting list for those other programs. So once we reach the top of the waiting list for one of the next programs, we can make the decision to see which program would be better or more beneficial for my son, and then either stay with the initial program or go to the next one. And ultimately, especially if you have a child with DMD and autism, and you're in Texas, the best program that all the parents rave about is C.L.A.S.S. It's Community Living Assistance Support with Support and Services. And this particular program includes a lot of the same services that you saw with the MDCP. However, they also include specialized therapies. And for those of you that have seen benefits for your children when they're exercising in a zero gravity environment, that would be with the aquatic therapy. And so this aquatic therapy is covered under the C.L.A.S.S program. So check with your state to see if you have any programs which are similar to these. One of the other therapies that would be beneficial for some of our kids with DMD would be the massage therapy. There's also recreational therapy and horseback riding. Therapeutic horseback riding is interesting. Hippotherapy is where you combine horseback riding with another therapy. The thought is that the individual riding the horse is more connected with the horse and more open for receiving, say, occupational therapy at the time. Brian, have you known anyone that had hippotherapy?
No, my son did receive aquatic therapy for a while, but there are other folks within the community who write about their experiences with these therapies, and the therapeutic horseback riding and aquatic therapy seems to be the most popular for Duchenne. It helps in developing the therapeutic horseback riding. It helps with developing trunk strength. Aquatic therapy, the buoyancy of the water makes it easier for these children to move muscle. There's some resistance so that they're actually getting a good workout, so that it helps them with maintaining a healthy weight. So these programs all have great benefits. The difficult nature of this trade-off is for families who don't have private insurance. It's really sometimes you have to make a Solomon type decision as to which is appropriate for you and for your child at the time, and choose between these programs. But certainly a lot of these therapies, if they're not offered in a special education program at school, sometimes this is the avenue that you have to go. And there's a comment in the chat that one of the participants' son has done hippotherapy for 2 years, and it's been really great. So I'm glad that some folks are taking part.
Oh, yes. And Carlita has said that hippotherapy has helped core heal and stretches.
Great.
Heal core stretches. Nice. Good. So this again would be offered to your child for free. What you would do is once your child comes off of the interest list for class or whatever the program is, you would first have your interview to see if your child meets the criteria, and then you would meet with a social worker to figure out what is allowed for your child out of that program, and then allocate the funds and resources that would best suit your child. So not everyone needs music therapy, but that is good for some of our kids that have anxiety issues. So again, if you're like me in Houston, Harris County, then you would call the local authority, which in my case would be the Harris Center. And again, this is a local authority that administers 3 of the waiver programs in Texas. Also, that is who you would go to get the determination of intellectual disability if you wanted to see if your child met the criteria for some of the programs which do look at IQ. So every state, I think, has some type of variation of this program. In Texas, it's called Get HIP. I think this is is it the Kate Becker, Brian, waiver that you were talking about?
Okay.
This is Get HIP. Get HIP is a program in Texas where if you have a private insurance provided by your employer who pays at least half of your premium, and you have covered under that health insurance program policy an individual that receives Medicaid. Now, it can be traditional Medicaid that your child may be eligible for once they reach 18, or it could be Medicaid through one of the waiver programs. What happens is, if you meet the criteria through this Get HIP program, then you will receive a reimbursement check every month for the insurance that payment that you're paying out of your paycheck every month. You'll get that reimbursed to you in full, not just the portion of the premium that covers your child, everybody. So for a family of 4 that is covered under employer provided health insurance, they would get a reimbursement check for the entire amount that's taken out of the parent's paycheck.
This is one of those programs that's not well known. So I've gone through most states' Department of Health and Human Services websites to try to identify these programs, and PPMD has a state-specific resources page, and under the bottom of the page, at the bottom of the page under health and wellness, there are, if your state has a HIP type program, there is a website or an email for folks to be able to identify and get that reimbursement. As Leona mentioned, in her state, they reimburse the entire family's premium. I'm in the state of Maine, and for us, I have to carve out what we pay specific to my son. So they'll pay the individual portion. So again, each state identifies what they think is important, and they create their programs based on that. A couple of quick questions. We have a family looking for some information about getting additional resources in the state of Arizona. I'll turn to that page, as well as a resource for possibly some of the programs. We have not highlighted every program that could be useful to a family with Duchenne, but there is some information there. Another family looking, asking about how do we sign up for the interest list in California, and I think this will be similar from state to state. Is you contact your state, your local, your county Department of Health and Human Services, Health and Family Services, and ask to speak with a case manager who works in this area, and hopefully they can help you to be placed on an interest list, or gives you the eligibility criteria and how to go about applying. And even if there is a denial, we always urge people to continue to reapply, and keep the greased or the squeaky wheel gets the grease. So that's what you want to look for.
With the Get HIP program, you'll also, you will have Medicaid at the same time. That'll be your secondary insurance. And so hopefully that will help minimize any out-of-pocket cost for the family. And then you'll have that reimbursement check. So that's another reason why you would want to sign up for Medicaid waiver programs. A lot of our families won't qualify for, based on household income and assets. They won't qualify for traditional Medicaid that would come with SSI. So that's yet another reason to make that call today, if you can, for your Medicaid waiver program interest list. So we talked about how long the wait is. In Texas, it's years and years before you would actually receive a call for an interview to see if you would qualify for benefits. And I actually, it was very interesting. Yesterday, I received a call from the Harris Center asking if I still wanted to keep my son on the 2 lists that he qualified for. And although we signed up in September of 2014 or 2012, we still had over 55,000 people ahead of us. But the good news is there is some hope out there. There's been reporting done about a segment in the proposed infrastructure bill that's tossed around in Congress now. So I have a clip from a article from CNN.com, and it's discussing that in the infrastructure bill, there is $400 billion. Hopefully that will be allocated to parents or whoever's going to be caregiving for aging and disabled Americans. So this would include specifically these waiver programs. So the goal is to eliminate the wait for all of these programs and start providing benefits so that parents can stay home and care for their children that have a disability. So go ahead, again, please sign up for these interest lists. So let's say you have signed up on the list. That is great. What do you need to do now? So you want to preserve your child's eligibility. Like I had said, at least in some of the Texas programs, for eligibility, you don't look at the household income and assets, you just look at the individuals. So then you're thinking, well, my child doesn't have any income. My child doesn't own anything, so we're in the clear. but you have to make sure that that is truly the case. Social Security Administration will deem child support paid to the parent on behalf of the child against the child. So you might need something called a special needs trust. The one that's relevant in Texas would be a self-settled or first party supplemental needs trust. And you would have the child support paid to the same parent, but in the role as trustee of the self-settled supplemental needs trust. And then we had spoken, Brian, about if you have let's say a personal injury lawsuit, and you've been in a car accident, your child was affected. They suffered a personal injury. You wouldn't want the judgment that your child would receive to compensate them for their individualized personal injury to disqualify them for government benefits. It takes a long time to get those benefits. We don't want to jeopardize that. So that personal injury money would also go into a self-settled or first-party supplemental needs trust. Now, there's third-party supplemental needs trust, and there's first-party supplemental needs trust. There are special expenses that are allowed to be have you spend money on, such as summer camps, medical bills that are not paid for through Medicaid, sometimes computers, computer apps, which may help your child if your child has a speech delay. Then you can pay for the computer and the special apps in order to benefit your child. Now for the first party supplemental needs trust, at least in Texas, usually we utilize the social security number of the individual who's the trust is made for. But in a third party supplemental needs trust, we have your own taxpayer ID number. So again, for first party supplemental needs trust, there are those benefits that you can take money that would typically be allocated against your child as far as Social Security is concerned, and counted against them as income so that they would disqualify for benefits. You can shield that money and put it in a first party trust. One of the issues that makes a first party trust not favored is that there's a payback provision. So there's a program called Medicaid Estate Recovery Program, MERP, and MERP allows Medicaid upon someone's death, if that person had received benefits from Medicaid, the amount that Medicaid had paid for that individual over their lifetime would be subject for reimbursement and be paid back to Medicaid. So for first party special needs trust, especially if you're utilizing it for child support, I suggest, although it's paid into every month into the first party trust, go ahead and spend that down. Don't use it as a piggy bank, because eventually that money in that particular account would be subject to a payback provision for Medicaid. You can use a third party trust. You can use a 529A savings account to protect your child's money that they're saving. Don't use a first party special needs trust.
So one of the examples we discussed in terms of the relevance of these special needs trusts is that if a child receives an inheritance and they have a sibling and they're not protected by a trust, the child who will with receiving state benefits will become ineligible if their asset limit is exceeded. And so they'll become ineligible for the benefits. They'll have to have a spend down period, which will pay for the services that they are receiving, while their sibling, who may not be receiving or who will not be receiving benefits, has access to that money without any limitation. So there's a disparity there. So you want to protect that money so that it is being used as intended for the benefit of that child. But you have to have a vehicle that protects it and while at the same time protecting their access to their state benefits.
Right. One of the strategies that we utilize for estate planning when we have a family with a child with special needs is that we encourage the parents to get a third-party supplemental needs trust agreement that they'll sign, and it will then create a trust. And so it's a standalone document. It's created at the time of execution. It will have its own taxpayer ID number. So my son's would be the Jonathan Third Party Special Needs Trust. That'll be the name of it. It'll have its own taxpayer ID number. So in my will, I leave everything to my son Jonathan. Well, actually, I don't, because I don't want him to directly inherit. So I leave everything 100% to the Jonathan Third Party Supplemental Needs Trust. And then within the trust agreement, that's where I name trustees. I suggest for parents to think about key people in your lives who are very good with money, and then key people in your lives that are very good dealing with your child and their challenges. So I have one brother who is very jovial, and he's going to be the person that I will, in my estate planning documents, he's the person I designate to be my son's guardian of the person. But I also want to think about the funds that I want to leave for raising my child if something happens to me. So the guardian of the estate is my other brother, who's very cost conscientious, we'll say. And so he's the one that's going to be the guardian of the estate. You know, so I have two brothers, and each of them will have a role if something happens to me. So as far as estate planning, I have the special needs trust, and so the trustee would oversee all the money and the assets in the trust, because the trust can own real property also. And none of that will be considered by Social Security as an asset of my son when they're trying to see if he qualifies for Medicaid waiver programs or later SSI and Medicaid. So that's one of the strategies that we utilize to properly, think out and strategize what is going to be necessary to help my child out for the rest of his life. So that's when you also, some people I've seen in their wills, they create the third party supplemental needs trust within the provisions of their own will. I discourage that as a estate planning strategy. And the reason why is that that particular trust will not be created until you die. And certain, some people, I saw one lady, and her will, she left everything to her son. And if her son predeceased her, everything to her daughter-in-law. If her daughter-in-law predeceased her, everything to these kids. And if those kids predeceased her, then to the child with special needs. And then they would have that trust created. Well, there's a lot of contingencies involved, and she probably paid a lot of money for that will that has that special needs trust. But then the special needs trust never gets created. Whereas you should just have a special needs trust as a standalone document with its own taxpayer ID number. And then you share that information with all the family so that they can, if they want to leave inheritance to your child, they point to the trust. They don't leave it to your child specifically. I have a question about making a sibling a trustee or a guardian. So definitely, I prefer that you list several people as successors in your estate planning documents. So for trustee of the third party trust, first it's going to be the parents. You're going to be the grantors. You're the ones funding it with $10 or $100. And the trust can sit empty without any funds until it's ready to be funded years down the road. You don't have to pay, you don't have to file any special taxes if there's no interest earned. It can just sit there. But everybody in their life insurance policies, when you can list your beneficiaries, go ahead and they list the trust and your special bank accounts or your retirement accounts. When you can designate beneficiaries and you want to designate and have your child with special needs, then go ahead and designate the trust. And then that way, your child does not directly receive anything and they do not get disqualified for those benefits that we were talking about. But in the trust, first you name the parents, so your grantors and trustees, then you list successor trustees. I recommend 2 or 3 different levels of trustees. And typically you may list, like in this question and answer, they're talking about the grandmother as a trustee, but she is getting older. So I would have grandmother as trustee, and then maybe some siblings or aunts and uncles or friends that you trust. And then some of the younger kids that are coming up in age and then that could maybe be around to step up and be a fiduciary for your child and their estate. And again, there are limitations for what can be spent out of the trust. Each state is going to have a list of allowable expenses, but it should be just about anything that will enrich your child's life, which would include the summer camps and the medical bills that aren't covered by Medicaid, apps, things like that. When we in Filis Law Firm have a family come in and we execute the special needs trust agreement, we go ahead and we get online with the IRS and obtain that taxpayer ID number immediately. There is no payback provision for a third-party trust. So again, when you're doing your financial planning and you do have your first-party supplemental needs trust, which has maybe child support paid into it, savings, go ahead and put it in the third-party trust.
So there's a question about the third-party trust and whether or not it's the same as an irrevocable trust.
So irrevocable, it is a type of irrevocable trust. Once you put in the funds, you cannot take it back. The grantor, when the grantor puts in the money. So we tell parents to go ahead and, if you want to, go ahead and open up a bank account with $100 or something. You're not going to get that $100 back. But in the trust agreement, although the trust is irrevocable, you can determine who the beneficiaries will be after your child, who is the initial beneficiary, passes away. So then that would be, that could be your other heirs. So although it's not going to return back to you as the grantor, you can still pass it on, any funds that are in that trust. So here's some more of the quality of life expenses that are allowed for special needs trusts. And then we had spoken a little bit about 529A accounts. So a few years back, there was some legislation that was passed at the federal level, and then each state had went ahead and created their own ABLE Act. ABLE stands for Achieving a Better Life Existence. And it's a way for kids or individuals with disabilities to save money and not have that counted against them by Social Security, which would then make them ineligible for benefits. One of the examples was there was an individual who had a small part-time job and wanted to save money to buy a car. But so the income was counted against him as far as SSI goes, so his monthly benefits were reduced. But the cash that was saved in the bank account was counted as an asset. And once, at least in Texas, once it reaches over $2,000, you then become ineligible for benefits. So there was the problem with saving money. So then around few years ago, the legislation came out where there's the ability to save money in a certain type of bank account called a 529A, bank account. And that is where an individual and their friends and family can put money that will not be counted against the disabled individual for benefits. There are special rules for each state. In Texas, I believe you can have as much as a total of $300,000 in this account, but only the first 100,000 is shielded from Social Security looking at it as an asset. So anything above $100,000, you don't want to put in this 529A bank account. One of the drawbacks, there are limitations on how much you can contribute. I believe in Texas, annually you can contribute up to $15,000 per year. But anybody can contribute to it, friends and family. One of the benefits of a 529A account, as far as estate planning and financial planning, is that it's a savings account, and interest earned from the funds that are in this bank account are tax deferred. As long as you do not spend the money inappropriately, then it's tax-free earnings. And so there are limitations on what you or your child can spend the money on. I highlighted transportation. That's always an important factor if you're going to modify your family vehicle in order to make it wheelchair accessible. There again, also from the 529A bank accounts, assistive technology, personal support services. If you need extra hands to help you out at the house with your child, then you can pay for those services through a 529 bank account. There's also, you can pay for financial management, helping you make these financial planning decisions. And then also legal fees are allowed expenses from a 529A bank account. So lastly, we have guardianship of the estate of an adult disabled child. In Texas, you, the biological parents, are the natural guardians of your child. But if your child receives an estate that needs to be administered, you would have to apply for guardianship of your child, of their estate. And many parents also look into guardianship of their children when their natural guardianship role ceases at age 18. And they need to continue caring for their child, making managerial decisions, financial decisions for their child after age 18. This is more important, I guess, or more relevant for parents whose children have DMD, and then they also, in addition to that, have a IDD, where 100% of care needs to be maintained in the parent, so that they are able to have the authority to make decisions on behalf of the child and just continue what they've been doing all of that child's life. So there is a legal process called guardianship. In Texas, it takes several months before you can finally have what we call letters of guardianship. So in the process, what we allow for in Texas is as early as 6 months before the 18th birthday, a parent can file for guardianship. There's an application process. IDD, stands for intellectual and developmental disability. And so if your child has capacity issues, intellectual capacity issues, and will need your help for the rest of their lives, then before they turn 18, at least in Texas, you can go ahead and start the process with an attorney who is certified to file for guardianships. What we do have for kids that require guardianship, parents can be co-guardians. Parents they will be interviewed by a court investigator. They'll be interviewed by an attorney ad litem who is the child's attorney. They will go through a training process where they may have to watch a video and register with a state level commission and have a background check, a criminal background check run on them. So after we have gone through with our parents through this process, then after the child turns 18, we can go ahead and have a hearing to have the parents appointed as guardian for that child. So for many of my parents, I don't want them to have guardianship of the estate. We want to do the financial planning and the estate planning so that the child has no estate. The third party trust can have money, the 529A account can have money, but we don't want the child to have money, assets. So we don't want to do a guardianship of the estate. We just want to have, if necessary, a guardianship of the person, where you can still receive notices from the school district when you have an ARD meeting. Because after age 18, they're not obligated to inform you as a parent because they can inform just your child. In doctor's offices, some of the doctors can ask you to wait in the waiting room instead of going back to the examination room with your child once they're 18. Access to medical records can be difficult after your child turns 18. Now, for a lot of our kids with Duchenne muscular dystrophy, there's not a intellectual component deep. So what we'll have is just physical functioning issues. But the child will still retain capacity and would understand and be able to read a legal document such as a power of attorney. Reading it, understanding it, and signing it in front of a notary is a lesser restrictive alternative to guardianship, but you're able to accomplish a lot of the same tasks being the agent for your child through a power of attorney. So as far as we would understand, if your child has capacity at the age of 18, you can have them sign a power of attorney to allow you to help them with some of their financial and business dealings. Now, while you're at it, go ahead and have your child sign something called a medical power of attorney, where you can help make decisions, medical decisions for your child. And then also something called a HIPAA release. This would allow you to have access to confidential health information records. Another lesser restrictive alternative to guardianship is being named the representative payee for your child for their SSI bank account. So guardianship, although it is necessary in some cases, especially where there's capacity issues, can be circumvented, and you can use lesser restrictive alternatives to guardianship to still accomplish a lot of the goals that you have in mind for financial planning and estate planning for your whole family. I have a question about your state does not have an ABLE account. Can you open an ABLE account in another state? Yes. Actually, the first state, I believe, to have an ABLE account was Ohio. And so a lot of our families have Ohio ABLE accounts, and they just never transferred it to or rolled it over to the Texas ABLE accounts. They don't have to. Some states will not require you to be a resident, but will charge you maybe a monthly fee if you're not a resident of the state. So I would check into that if I were you. Due to the large time commitment, how do I become a paid caregiver for my child in California? Okay, so some of the waiver programs do allow parents who are guardians to also be paid as caregivers. That's going to be very state specific. So I would look into it. In some cases, you're only allowed to pay trained outside service providers. And in some cases, you may be hired as the parent, you may be hired to be a caregiver if it's allowed through the guardianship program. Let's see, there is a such thing as a 529 bank account. We have a question about a college savings account. So a college savings account, a 529 account, will be counted as income by SSI. So that is why you can roll over the 529 funds to a 529A bank account, which is called the ABLE account.
So going back to the prior question about paid caregiver as a parent, some states do allow this, and it's in a patient-directed Medicaid program. But again, there's 50 different models at bare minimum. So those are that's something you have to investigate at a state level, and that's what you'll look for. And that's typically with an adult, a parent caring for an adult, because the adult patient is of age and they can direct who they hire to care for them and that sort of thing.
There was a question about what happens to the funds with an ABLE account upon the death of your child. So at least in Texas, an ABLE account is subject to payback provisions in Medicaid, just like that first party supplemental needs trust. What some parents do is they will, there is a beneficiary designation of beneficiary form in Texas for ABLE accounts. So you can pass the funds on to a family member, whatever is left over after birth has taken funds out of the account to get reimbursed for Medicaid expenses that were paid for the benefit of the individual during their lifetime. So you're saying Deanne is saying that in Michigan, all the money stays in the account and not to the family. So every state had the opportunity to create their own ABLE Act. And so that every state has different rules. So I can talk to you about Texas. There's here's a message from Sarah. Let's see, you have a brother who's 40 and has IDD. And he has not been put on any waivers, and there's no guardianship in place. So in Texas, usually it's only one guardian per proposed ward. There are exceptions where you can have it if it's the biological parents or the applicant has a spouse. And so you can have co-guardians at the same time. You would, in Texas, when you make an application for guardianship, even if it's for your 40-year-old brother, you have to have him served with paperwork from a constable to give him a notice that someone is filing a guardianship for him. And then you have a duty to alert and inform certain family members of the guardianship, and they can sign a waiver where they're consenting the guardianship and don't want to interfere at all, or you can have a contest. It is up to you. You can go ahead and apply for guardianship now. You said your mom is still taking care of him, but she is getting up there in age. So if you apply for guardianship of your brother, who's 40, you determine where he lives. You can still say he lives with your mom. That you would just have authority to speak on his behalf at the bank or with the benefits programs. You can go ahead and sign him up for Medicaid waiver programs that he isn't signed up for. Legally adopting is different than guardianship. In the chat, there's a question about would you have to legally adopt him to add him to your insurance plan? I'm not sure of that. The different insurance plans have different thoughts, different rules about who is deemed a dependent. But legal adoption is a little different than guardianship. It sounds like guardianship is appropriate here. Adopting him, you would be his parents as opposed to his guardians. You can change his birth certificate to have your names listed as parents. It's a completely different process, at least here in Texas. It's a different court system. So that is a thought of adopting, but I don't think you would, I don't think that would be beneficial to for financial planning or estate planning.
Well, the other impediment with that is with the Affordable Care Act and the essential benefits. Once an individual reaches age 26, the private health insurance does not have to cover an individual. So at 40, he would be ineligible to be covered by a family's insurance plan. So there would be no benefit in that regard either.
Mhm.
So we've reached the top of the hour. I want to thank you very much, Leona, for this excellent presentation. I think, as I mentioned before, it's a very information-rich session for families who have attended late and may not have gotten my earlier message. I'm happy to send a PDF version of Leona's slides. You can just email me. It's Brian, BRIAN, @parentprojectmd.org. And over the next day or two, I intend to respond to anybody who is looking for that version. The session is being recorded, and it will become available approximately 2 weeks after the conference. But if you'd like some of that information earlier, I'm happy to make that available to folks as soon as I can respond to your messages. So thank you very much, Leona. This has been a wonderful session.
Thank you so much for having me.